There we go. So we are live. Thank you. Good morning. Today is Tuesday, February 27th, 2024. It's a little after 10 a.m. This is the meeting Senate Natural Resources and Energy. And we're resuming our work on Bill S-258, Act relating to the management of fish and wildlife. We discussed the bill last week and had a markup session as a committee. And so I'd like to ask Mr. O'Grady to join us at the table. We'll look at a next draft. I met with Mr. O'Grady yesterday, so thank you for providing a new draft today. And as you often act like the committee's whatever messenger editor, trying to bring as best I can tell what we brought together as a committee of issues. And so these are proposals of amendment, not final language, of course. Okay, so Mr. O'Grady, if you could walk us through, please.
So you, this is what you're ready to let Senate Council get draft number 2.1 dated February 26th with 3:27 p.m. Time stamp and middle of that grade highlighting in exchanges between draft 1.2 and 2.1. You want me to just walk through changes or the entire bill?
I'll move to the entire bill sort of on the light side, but slow down and dig in on the new language.
Okay, the first section relates to the establishment of the Department of Fish and Wildlife and its authority. So in addition to the authorities that is granted under Title III, has those authorities that are granted under this part, Title 10, Part 4, and shall implement the policies specified in Section 4081. Then you will see on page 2, there is established the Fish and Wildlife Board. Purpose of the board shall be to serve in an advisory capacity. This is new. The department and then the establishment of department rules and policies therein. So there had been language previously that said that the board would serve an advisory capacity in the establishment of department policies and rules. Apparently that created some anxiety for the department that they would have to run every policy that they work on by the board. So this is now any department rule and the policies contained within its.
Nice. Did we have a reaction from the agency on if that resolved their concern?
Not yet, but I was so we're just getting a draft this morning. So
Page 2, line 4, this is the composition of the board. Currently it's 14 members, one each from each of the 14 counties, appointed all by the governor. You are changing that to 15 members, 14 of which are from the relevant 14 counties. But there'll be one at-large member. 5 members shall be appointed by the commissioner, 5 by the speaker of the house, and 5 by the committee of committees. There's language about what happens if they resign or move out of their county. And then you get on page 2, line 17 through 18. Currently, a board member can only serve one full 6-year term. Page 2, line 17, 18, the chair directed me to allow for a member to be eligible to serve a maximum of 2 6-year terms.
I think what sometimes when you're on a board, it takes a while to come up to speed and wanting to push people with institutional knowledge, really know what you're doing proper and make them knowledgeable for things.
So moving on page 3, in order to be on the board, you have to apply to the appointing authority. In considering applicants, the appointing authority gives due consideration to whether or not the members have a history of involvement with and dedication to fish and wildlife, including the knowledge of fish and wildlife biology, ecology, and ethics of fish and wildlife management. There is also going to be the consideration of the appointment need for the board to have a balanced representation and include members of the public in new languages and approximately equal number of licensed users and non-licensed users. 15 people, you can't have people, but you can have close to.
Opposed to, people that make the previous language saying balance, people worry about seem they, so. Approximately equal, it's as close as the common thing. What we, and this defining balance. No, wait,
Thank you, Mr. Chair. There had been some discussions about, whether or not we wanted to have folks who have a science background have a more called out number of participants on the board. Did that, did you have a discussion about that? Was there any consideration for adding that into the bill, or where did that land?
so it came up, after committee on Friday, I think, we talked about a little, I emailed them back about it, senators back about it. I think they discussed, my thinking was that, we, so often the people who are on citizen board have, they're not necessarily always formally a scientist, but they may be very well educated in the subject. And so it's, I didn't ask Mr. O'Grady to put that in because I was uncertain about it. And my own reaction was we might unintentionally, I understand the attraction to having people that scientific backgrounds. My hope was that the language we had already would draw people with appropriate knowledge, but not unintentionally exclude someone who wasn't sort of officially a scientist in biology, but and we've had some witnesses that I don't think they're formally credentialed, but they have been interested in topics that all over the country. No, happy to talk about it more. Senator Watson?
Thank you. Actually, just as a matter of process, if we have thoughts or suggestions.
Yeah.
For a particular part, do you want us to raise them as we go, or bring them up at the end, or what would?
One reads, one would flag them, but this one,
Yes.
science question,
Okay.
and help us remember
Okay,
back to that.
super, thank you.
Um,
Okay, moving on page 3, there are definitions of what is a licensed user and a non-licensed user. The chair wanted to clarify that a licensed user is one who held a Vermont County fishing or trapping license in each of the previous 5 years prior to appointment, and a non-licensed user is a person who has not held such a license in any of the previous 5 years prior to appointment.
let's try and make it a very bright fun.
On page 4, there is, or there was in the previous draft a requirement that each board member receive training from the department on a number of issues. Apparently, there's been some concern that was too balanced or unbalanced in one direction. So what has been added in is that they shall receive training on wildlife management and hunting ethics, such as the North American model of wildlife conservation. But they will also get training on wildlife biology, coexistence with wildlife, the reduction of conflict between humans and wildlife, and the impacts of climate change on fish and wildlife.
Thanks.
So it's, so, council, offered up the idea of citing the North American model of wildlife conservation as a long established program. Known to a few people on sort of whatever, both sides of the issue. So that's where that suggestion came from. I meant to make a copy of their, a summary of what their model is. I'll get that for people on the committee so you can see it. They're like,
Thank you, Mr. Chair, and I appreciate this addition. I think the reason that some of us had asked for it was we had been hearing from constituents that while there was a focus on potentially the non-licensed angle of training, there wasn't necessarily an angle for the licensed folks, so we want to have a mixed experience. We had spoken about potentially requiring hunter safety in this part. Was that a discussion that was had?
we can have it, I actually called one of the Fish and Game Department's instructors for that program who provided testimony. and talked about it and shared this as an alternative and.
Okay.
He thought, this was my understanding was that he thought this was such a long established, well-known standard, that it would be a really
Okay,
useful thing, but
That's-
certainly
thank you for
open
doing the due
to
diligence.
better,
Thank you.
So on page 4, line 6, you're coming into the process. By which the department shall engage the board for the purposes of proposed rules. They submit proposed rules to the board for review. There's a public hearing and opportunity for comment. Board considers whether a proposed rule is designed to maintain the best health population viewing opportunities and utilization levels of the regulated species of other necessary or desirable species that are ecologically related. If the board by majority vote determines that a proposed rule should be revised, it submits a report to the department setting forth its recommendations. The board shall include with it a report the public comments are received. The department fully considers the recommendations of the board. If the board's recommendations are not included in the department's rule, the department issues a written explanation of why it did not include those recommendations in the rule, and then the board's report and responses, the department's responses thereto are given to LCAR. From page 5, lines 4 through 7, this is just an obsolete, duplicative section. It's duplicative with previous 82851, which it cites, so you don't really. Page 5, line 8, section 2 is the policy statement for management of wildlife in Vermont. The first change is on subdivision 4081A2 on beginning line 16. So the Commissioner of Fish and Wildlife shall manage and regulate the fish and wildlife of Vermont in accordance with the requirements of this part, and we say part 4. Including the Department of Fish and Wildlife rules on non-game management as set forth in the Code of Vermont rules -0/0/0-026. And then on page 6. Is clarity of public welfare to protect, manage, and conserve the fish and wildlife in the state and the habitats in which they reside. It's a technical amendment on page 6, line 4, just striking and after fish. And then it was going to marine fish, comma, wildlife, comma, and primary animals. Page 6, line 7, the commissioner shall commence rulemaking to develop a non-game wildlife plan required by subsection 4048D. This time will not later than July 1, 2024, and should complete rulemaking not later than September 1, 2025. You could keep this here in statute, or you could move it to session law. Either has the force and effect of law.
Right.
This does have dates that are going to be quickly obsolete.
right, feels like, that's a lot of the better home.
So do we need to do anything? We just take.
It's like section.
Pardon?
But how does, it's a mechanical question, how do we make that part of session law instead?
You take it out of the amendment to the statute and you create a new section, a transition section or implementation section. And you just put the same exact language there.
Okay. So it's own section, it can be.
Right.
Since it's a one-time event, it will quickly be done again. Thank you.
Then there are a bunch of reporting amendments, shifting authority of the board to the department. But before you get to that, on page 6, line 17, currently, the primary goal, Fish and Wildlife Management, is an abundant, healthy deer herd. And you're changing that to a healthy deer herd is one of the most important goals of Fish and Wildlife Management.
The editorial comment is, that, yes, of course, it's probably one of the highest profile species that people go hunting for, so that we do want, for sure, a healthy herd. But to make it primary, privilege is over all other species, and we're looking for scientific principles to manage population levels, not to choose, not to favor one over the others.
So moving on page 7, all the changes here are changing board to department for purposes of setting the antlerless deer season, having public hearings about deer herd. When they determine an antlerless season is necessary, all changing board to department. On page 8, there is literally no change. Page 9. You're in section 3, you're in the authority for the Vermont Fish and Wildlife regulations. Generally throughout the section, you're changing board to department. One of the things that the chair and I discussed is the scope of these regulations and whether they are currently just for those species that are subject to fishing and hunting licenses. Fishing, hunting, and capping licenses. I take the position that these rules are already broader than that because they already are supposed to address other necessary or desirable species that are ecologically related to a regulated species. So it is not just the regulated species that are subject to taking, it's beyond that. And so to clarify, after discussion with the chair, scope, the Fish and Wildlife regulations will be for the management of all wildlife. And the regulation of Fish and Wild Game and the taking thereof. So it is not just for that subset of wildlife that is subject to taking, it's for all wildlife.
So that, right, and the phrase struck right below 7 to 9. Makes the point in a more nuanced, in a just different way, whereas council's suggestion to make it very straightforward and clear seems helpful. Management of all wildlife,
So
no misreading.
moving on through the rest of that section, you're just changing board to department. On page 10, you're making similar changes. Or striking reference to the board of as you are on page 10, line 14.
Oh, I'm sorry.
I hope this isn't too philosophical, but. The management of all, I know that's a term for a lot of us, but it is accepted. It always seems to me that actually wildlife does a perfect job in managing itself. That what we are talking about here is managing human activity relative to wildlife. I'm not gonna throw myself on the sword. I'm wondering if. The mindset of managing, that we manage the wildlife. And what we really have is a business like managing what humans do regarding.
I understand your point, but it is a very common term throughout this title, this part. To conserve, manage, protect, manage and conserve. I mean,
It's another bill.
Hubris here.
it could be a very long.
Well, we've had Bill Dickers change, go through the green books and change language.
Believe me, I'm aware I have to.
From he.
It's a summer job.
Okay,
It's good, but they behave, yeah. Said what?
I hear your point. I actually am not sure that I agree. I'm open to. More science on that point, but I actually suspect that. With invasive species and. And then. If we want to purposefully conserve. Some populations, it might actually take attention. intervention. But that's just a hypothesis and I'm going to be wrong, but I don't know, I don't.
Yeah, I do think it's probably a different discussion. You and I may trade arguments.
Yes,
I mean, may well be right.
I'm willing to be wrong.
I think you're both right. One's a more philosophical statement, and the other is looking at maybe for sort of kind of already. Right, so, for now, let's look at some of our game. If, anyone wants to discuss it further, we will. I'll leave it flagged on my.
So moving on, page 10, again, in the board's department. Page 11. For years, the House has been the only committee that's been receiving the harbor permit numbers at one of this year. I have an idea why that is, but I won't go into that, but now we will be receiving that report as well.
No,
Page 11.
answer this question.
This is
Is that like spike horn deer or what is that? What is it?
They don't have antlers, so.
So it's doe,
And young,
so it's not, when does it become? Well, I guess I can, I'll look at the,
There is a definition in the rules about a spring corn. And whether or not they qualify as antlerless.
and do they?
I had to go back,
Oh.
I had to go back and look at the rule.
There's not a different report though that we are not getting on that.
Well, you also get the annual deer report, which will include all tier.
Oh. Thank you.
I would have asked, if we had, just because it's very common to have a report it out for the listening.
It's from a long ago, kind of,
Representative, who's no longer here.
yes.
Oh.
Long. On page 11, section 4, taking a fish, you're changing towards the department. You were striking the reference to the Fish and Wildlife Board being a non-advisory, meaning they currently are kind of carved out of the provision that any board that is within the agency is advisory. And this provides, current law provides that they are a regulatory board, but you are striking that and they will no longer have a regulatory capacity, they would be an advisory.
Can I answer the question on this? How come subsequently learned that there's some other boards, I think like Agency of Education has some advisory.
Well, these are the board within the agency that resources. So the Title III, the numbers that begin with 28, they relate to A&R.
I thank you. Explains it. Learn something every day, hopefully.
Page 12, section 6. Senator McCormick was just noting that you can direct legislative council to change terms throughout statute. And that is what section 6 does with regard to changing board to department. There are specific references that are set forth on page 12, lines 11 and 12, and then there's the general authority. Page 12. So we literally have that walk there is we'll have to read that. Page 12, line 15, this is transition section. Senator Watson, this is probably where I would that language right here. So the rights adopted by the Fish and Wildlife Board and in effect as of the effective date of this act shall remain in effect as full enforcement of law. So such time as they are repealed or amended by the General Assembly by legislative act. Or by the Department of Fish and Wildlife for certain against chapter 5. And I note this whenever I do these on page 12, 19, and 20, the General Assembly can directly amend Fish and Wildlife rules because you created those rules in statute, and when you did, you gave yourself authority to implement that. Page 13, the members of the Fish and Wildlife Board as the effective date. Continue to serve as members of the board until all new members of the board are appointed. For 90 days after the effective date of the second, whichever occurs first. I think 90 days, you might think that that's more than enough time. There's 15 people, new people,
Also summer.
also summer. Sometimes appointments take longer than you would think. So 90 days, I think, is probably okay, but don't be surprised if somebody
Is missing
flag.
on the 90th day.
Section 8, these are the general definitions for Title 10, Part 4. And what you were doing at the end of that section was adding a new definition of trapping. This is actually what trapping used to be defined as prior to the most recent Fish and Wildlife Board amendments to the rules. So this is just codifying what the definition used to be, meaning to take or attempt to take fur-bearing animals for traps, including the dispatching of lawfully trapped fur-bearing animals. Moving down on page 14 in the section 9, these are setbacks for trapping. I believe a previous run through of the bill, you discussed whether or not there should be a setback from roads. And so that always raises the question, what is your problem? So public highway means any highway is set to the term is defined in 24 VSA section 4. 24 VSA section 4 defines public highways, they have to be public, so it's not a private road. It includes class 4 roads shown on the highway maps of the respective towns made by AOT, but shall not include trails. This is a different definition of trail. So path or corridor open to the public, including all areas used for non-motorized recreational purposes, such as hiking, walking, bicycling, cross-country skiing, horseback riding, other similar activities. So why on page 14, line 15, is that language, the public comment, including highlighted? Because there used to be language about it's a path or corridor or any other area reasonably expected, where a person may be reasonably expected to recreate. But the chair pointed out to me that that language, as posed most recently by the board, was not in relation to trails, it was relation on page 15 to a 100-foot setback for buildings, parking lots, visitor centers, parks, playgrounds, picnic areas, shelters, pavilions, school, camp, or campgrounds, recreational facilities, or any other area where persons may reasonably expected to recreate. So that is a current setback in the current rules. Just moving that in. What would be different is that last phrase, page 15, line 4, also page 14, lines 19 to 20, that these setbacks apply when the trap is set in water or under the ice. The rules did not have the setbacks apply when the trap was set in water or under ice. These setbacks do apply in water or under ice.
So does that make sense? So we had already been more protective of places that people be recreating with a plate on its foot. Then trails, we had already talked about, but many people use roads, especially like class 4 roads, that's not a de facto trail. So we're bringing roads, highways, trails, and then clarity on playground for them.
Thank you, Mr. Chair. We've had a back and forth about vast trails, snowmobiling trails, side by sides, if you're in one of those, on a side trail. my interpretation of this language, which could be wrong, is that those are covered. in this.
It would be covered except
And it's the
Your
same.
wish has been anticipated, your question's been anticipated.
page 15, lines 5 through 8.
I like that, yeah.
This is effectively a landowner exception. So if you are a resident or non-resident owner of land, the owner's spouse, the owner's minor children, the setbacks do not apply to you when you are trapping on the owner's land, regardless of whether the land is posted under section 4710.
Okay, so can I explain my example and you tell me if it's falls under this?
Sure.
So in the instance that I am someone who traps. And I have a vast trail that runs through my 100 acres or what have you. I do not need to have a setback to that trail to put my own traps or my wife's traps, or if my kid comes and wants to put a trap out.
That's what this language does, yes.
If I have a very good friend who is unrelated to me. What happens in that instance?
That was part of the discussion that it was determined not to include your grounds.
Okay, it's not include your friends, but let's say I put the trap out and my friends happen to be the people who check it every now and again. But it's my trap, I take liability for it, or
Name on it?
if my name is on it,
Sure.
so that is helpful. Thank you.
And, you know, for a backstory, there were conversations with, there are some large property owners with vast trails who felt that if this setback provision was then going to apply to them, that they, on principle, felt like they would end serving as a vast trail in order to preserve their own right to set where they wanted.
I did send the language to one of the interested parties. Unfortunately, I forgot to do it until this morning. So I haven't heard back.
Well, I think that this is a very good compromise, and especially if you are someone who does trapping on your own land, I think that this is reasonable because you are responsible for it. If you are having your friends come and do it, it is harder to keep track of that, and I think there's a greater risk of someone getting hurt. Because you as an individual don't know necessarily where it is, but my hope would be if your spouse or your children or you yourself are putting out the traps, you would have a pretty good sense, and then you would be responsible for the situation. It feels like a good way to avoid injury. So thank you for taking the time to consider that.
Should I move on?
Yes, please.
Page 1599, section 10, this repeals those Fish and Wildlife regulations in the rule that are now being added by statute and or are inconsistent with what is in the proposed statute. So you're getting rid of the definition of trapping. That's the definition that define trapping as something. You're getting rid of the definition of legal trail and public trail, and you are striking the setbacks because you have put them into statute.
Question.
Thank you. All right, so I a lot of questions about this section. I'm feeling like I have a little more clarity, but I'm not. I want to check. So in some of the language that we just went through, we have like a definition of I think we have a definition of public trails, right?
The definition of trail.
A trail. And not legal trail. We did have a definition of taking. Did we have a definition of trapping?
Yes, the definition of trapping was added in.
Okay, and so, oh, there it is. Okay, yep, thank you. So all this is doing is if we just redefine some of these things, we're removing the previous definitions. Is that?
You're removing what's in rule because you've now adopted statute that conflicts with the rule.
Okay,
And when a rule and statute conflict, the statute controls But it's best to eliminate those and remove those, so people aren't reading law and the rules that is actually not valid because it's been statutes. That would make this a lot clearer by going in and actually amending the rules. So you will see what the language is that's being struck. It's just gonna make the bill longer.
Yeah, I would describe it to be the same reason. My way of saying is, all the things that were alluded to here, we've written statutory language for them. And now we're tidying up the rule saying, well, this is what is gonna control, so we'll take that out, leave that from the rule, so someone doesn't read it and come to the wrong conclusion, unless they were aware that it's a rule and statute, and they knew that the statute controlled rules, they could be misled, so it's really kind of about public service and clarity.
And one question about. Lines 13, 14, on page 15, the definition of legal trail and public trail, we did redefine those things. Are there gonna be cross references to a legal trail or a public trail that now are definitions?
So the only use of legal trail and public trail are. Uses are in the rule. And you are eliminating that on page 15, line 15.
Thank you. All right.
Sure, please.
You're now moving into the part of the bill related to hunting coyote. The first thing you're doing is adding, I'm gonna have to renumber page 15, line 17. It's a little complicated. When you enacted the directive to the board to adopt rules for hunting coyote with dogs, you also put in 2 statutory sections, one of which was a permit that was in NBSA 5008, and one of which was a directive about seeking landowner permission and when a homeowner or property owner to notify an owner of dogs to stop bringing dogs onto their property.
Those are the provisions that accompanied that moratorium.
Yes.
Yeah.
When this bill was drafted. 10 USA 5008 did not exist yet because it was still subject to. The board filing its rules. And now the board has filed its rules, 10 USA 5008 is now law. And so I have to change how I drafted. I have to change how I drafted that ban on page 15, by 17. Because it's really what.
It's not added
Right.
anymore. It's
No, so I would have to amend 5,000.
Yeah. Okay.
And in addition, on page 16, I repealed 5,008. And so I don't want to do that. I want to just repeal 5,000.
Okay.
Sorry, I should have. Ready to list that.
Senator Ponce.
Thank you. By. Prohibiting the use of bait in coyote hunting. Are we effectively banning coyote trap?
No, because you added language that says person shall not take. Coyote by using bait except as authorized pursuant to a trapping license under this part.
That's my clarification.
Oh,
So you're,
yes, I'm repeating.
no, you're on track, and I was keeping track of that question and then said, oh, well, we were, for instance, with nuisance traffic, you might well be. But it was big piles that were drawing coyotes in, that seemed like not, out of their practice.
Okay,
Hard to claim an animal as a nuisance because it shows up, putting out the big ones.
okay,
But bait related trafficking, and there's still
It's
some
still-
nuisance traffic, for instance, it's true. Well, then you would, it would be fair to say, oh, you bait traffic by.
The same, are you,
I am done, thank you.
the same highlight one, except as authorized pursuant to a traffic license issued under this part, how would that speak to a farmer whose livestock is being, has one way or another, has a coyote problem with his livestock?
So
Is he allowed to,
this language does not amend the nuisance trapping authority. So you can still trap for nuisance wildlife. Now, if you were going to trap for coyote, that you think is a nuisance, I would recommend that you contact your local fishing game warden first. Let them know that you're doing it and to let them know why and for them to basically sanction that.
We may get that question on the floor when we bring this bill, so that's.
I certainly got that question a lot over the weekend, and that was my answer, that one. It's nice to know I was right.
Okay,
So just did eight. Then you're coming to page 16, section 12. The repeal provisions. Yeah, I have to make that change on line 7.
Yeah.
Will not say, 5,000, they can say $5,000. And then the 2021 action results number 165, section 2. That was the repeal on the moratorium. You probably don't need that anymore. Same with 2021 action results number 165, section 3. But they've already effectively been triggered. Or so you could just strike them.
okay,
But then the following subsections are what the board added in its rules and that you are removing because they are inconsistent with your statutory prohibition on taking a coyote with use of dogs. So the first is a definition of a company for purposes pursuing coyote.
sorry, Senator Down, you have a question?
I understand the rationale for prohibiting hunting coyotes with dogs. And to my understanding is that in the absence of any rules. That require dog being under control. That this is the option that's left. If someone were to come up with a way to keep dogs, hunted coyotes under control. I don't have any suggestions, but then presumably, that could be reopened at some time. I mean, it can all be reopened, but why, the reason we are banning hunting of coyotes with dogs is because efforts to have those dogs under control have yet to be promulgated or put into place. So,
Yeah, I mean, that would be. For the bottom line. We have testimony about devices that let someone know where they are. But, where it can be, I just checked this weekend, Garmin units track of 9 miles away. Just an animal 9 miles away. You don't know what it's doing. You may know where it is, but it. To me, it has a concept definition. How's it?
Okay, moving on. Page 16, line 16, you are removing that definition of control. Because you can no longer take coyote dogs. Same with the definition of coyote dog permit, registered dog, packet dogs, related dogs. Sub-permit key that accompanies you. When you have a permit to hunt coyote with dogs, page 17, line 1, definition of taking coyote with theater dogs. Definition of a training control collar, definition of a registered dog, and then the substantive rule. Section 4.20 taking coyote with theater dog. Then page 17, lines 5 through 10. The commissioner shall not issue a permit to hunt or take coyote with theater dogs after the effective date of this act. If a person submitted an application to hunt or take coyote with theater dogs as of the effective date of this act, but has not been awarded a permit, the commissioner shall not issue a permit, shall refund permit with any fees. There had been a previous question about what about those permits that have already been issued. The chair and I looked at the rules with that, the kind of practical reality. The season ends March 31st. You're likely not gonna get this bill approved by both bodies by that time. So it's really irrelevant to address those permits.
Thanks, Aaron. Why mention the white?
Thank you. I have an like a question that's not related specifically to the language of the bill, but as a constitutionality question. But I realize that that's a different tax, so if yours is like related,
Oh, yeah.
so then I will defer.
Oh, well, I want to hear your question, but my question was, so can people get a license up until what point? So like, my only concern is, let's say March 31st happens, you say, wow, great season. I want to get my permit in I want to get it in on, April 1st.
So the
Are
application,
we not allowing people to get, I just don't want a situation where people are getting an application in and a permit and then,
the application deadline was January 14th, I think, 14th or 15th. And, but the longer it takes to get this bill enacted, the more opportunity the department has to reopen the application
Yes.
process.
when do they reopen typically?
I don't know, because this is a first season for this, so they opened it within like a week of the rule going into effect. So I couldn't say when they would open it next year. I couldn't even speculate.
When do they typically open the process for other seasons? Like how early in advance can you get like you can get it like the year out, so.
Pretty early.
Okay, so my only concern is the situation in which the season is over and folks are jazzed and wanna get signed up for next year. They would not have used that that permit yet, but I don't know that's my only concern. It seems like there's a lower risk of that though, because I assume these people.
I think if you pass this. Let's just be realistic, it's probably gonna get vetoed, right?
Yeah.
So if you pass this. Go to veto session, which I think is gonna be right at the end of June. I think the commissioner and the department probably shouldn't be fulfilling any applications until after that. That veto session.
Is there a way for us to signal that or to, because my only concern is that they will get applicants and they will accept them, and then that will be our argument for not overriding.
But remember, if you override the veto. Then the department's gonna have to they won't wanna return all the money, they won't wanna do that. So I think the practical administrative burden on them. Of returning and refunding. Is something they will not want to do, so they will wait until after the veto session.
I think that's a totally reasonable, rational choice that someone would make if they were keeping track of this stuff. Thank you.
All right.
So that is the bill. Everything goes into effect on passage.
Chapter 1, Article 7.
Yes. Somebody raised constitutionality question, and I would like to check it with you. So the part of the Constitution that. Yes, chapter 1, article 7, so the government is or ought to be instituted for the common benefit, protection, and security of all people, nation, and community, and not for the particular emolument or advantage of any single person, family, or set of persons who are a part only of that community. So one hypothesis is that so structurally, you don't have to be a sports person to be on board. So it's not just structurally in violation of that, but functionally, because all people that are there are sports people, does that make it unconstitutional?
So the question is the common benefits clause violated because the only persons that are appointed to the Fish and Wildlife Board are sports persons?
Where the rule makers.
The rule makers are all. The rule makers are all part of those, they are.
So common benefits clause is actually a very low threshold. If you're not dealing with what are called protected classes, then it's just a rational basis test. And the state just needs a legitimate reasonable interest for regulating in that way. And I don't want to make the argument of why it's reasonable and legitimate. I think people can make many arguments for why it's reasonable.
That what is reasonable.
That the current composition and basis for appointment is a reasonable basis, serving a legitimate interest.
So it's not, you're saying it's not necessary, like you could argue it both ways, is what you're saying.
Yeah, I could argue it both ways. I just know that the common benefits clause, unless a court says that the interest is a constitutionally protected interest, then it's a really easy test to pass. And I'll give you an example when it's not easy, and that is education funding. Because that's when the court said that it's a constitutional right and it's not the constitutional right to an education, it's a constitutional right to access to funding for education. And that, therefore, the way that the system was set up when the decision was made, it was not legitimately doing it. It was discriminating against person, and was discriminating against access to equal funding for certain students. And so that's why the state had to redo its education property tax system. Here, what would be the constitutional right is that everyone has some common public trust ownership of wildlife. And therefore, the board that regulates wildlife or the taking thereof should have a composition that reflects that. Well, the public trust is something that you, the General Assembly, hold in trust for all of its citizens, and you, the General Assembly, can dictate and delegate how that public trust is managed. Why do you do it in a reasonable way with legitimate interests? So I really don't see that common benefits clause argument in success.
Okay. That is all I need to know, thank you.
Seven Marley.
And we both agree that that question, if it's controversy, would have to be decided by court ultimately. Because my sense is that the argument. I think the question here implied is, what is this board in the first place? It used to be called the Fish and Game. The name was changed. When the question comes, was the name changed just a smiley face? Or does it mean something? There is a difference between a Fish and Game board and a Fish and Wildlife.
Yeah,
There are people with an interest in wildlife in ways that do not involve an interest in game. And only people who deal with wildlife as game manage wildlife in general. I think I'm not sure the argument went. I'm not aware of it. But I don't know how important to decide that, but I think a very strong case can be made that this is a common benefits clause.
So we create, rather than have the court decided. We are deciding.
Right, just because it's public trust, we're the legislature, so we decide how to do our due diligence protecting the public trust.
Okay, anything more?
I have a lot more, but I don't know. I agree with you, a court is the one that ultimately would be to determine. That question, it's a court to interpret the law, the executive, ministers, and the general assembly that exists. The, so. The public trust doctrine. As applied to wildlife. Has a little ambiguity around it, you will hear people say that because the Constitution provides a right to hunt, fish, and fowl, that means all the wildlife in the state are constitutionally held as a public trust. And there is a Supreme Court decision from like the 1800s that says something very similar. That is not what the Constitution says. The Constitution does not say that the wildlife of Vermont are held in trust for the people of Vermont. Supreme Court decisions, as I think you are all well aware of, can be overturned. That is why Beat the Moose times, I don't even remember the year. That the General Assembly wrote into statute that the wildlife of the state of Federated Nature are held as a public trust. That's a statute. It's not a constitution, it's a statute. So it's not a constitutional right. Statutory right authority. That you gave yourself the ability to delegate that, which you did, delegated to the commissioner through the commissionership board. So you delegated that statutory right. I don't agree that it's a constitutional right. I was the one that broke the public trust provisions for statute.
Okay, you might.
Sorry.
Thank you for giving. Sarah McDonald.
I don't have a problem with saying that there's can hunt coyotes with dogs if they had them on, if they had their dogs on a leash. But that's probably easy to say because few people would be crazy enough to hang on to a leash with dogs chasing coyotes. But basically, I don't have a problem with anybody who wants to hunt a coyote with their dog on a leash. And it's not in the bill that we propose. I'm just thinking, maybe when I put it there, that would be bothering me at all.
I also wanted, we have a little bit of time, is just ask you if you could briefly. There was, a preliminary injunction was filed after the rule went into effect. Over the, I think, the lifting of the moratorium. Can you just give us a brief update on? And some people said, oh, well, the court decided, not to issue the temporary restraining order, therefore. Well, but therefore, then some makes an argument about. The validity of the current rule. The right law, we're not dealing with the rule.
Thought I had that decision, but I must have left it on the printer. So basically, when the official wallet court filed its rules over the objections of Elcar, there were interested parties that initiated litigation to basically seek an order from the court that the rules, especially those that Elcar objected to, were not valid. Because they were inconsistent with legislative and or were arbitrary. So as part of that litigation, they sought a preliminary injunction. The standard for a preliminary injunction is a high standard. Basically, it is when you are seeking immediate relief. And the court has a 4-part test that looks at any preliminary injunction to see if the standard that if the requested relief is really in need of immediate relief. And the court here said no. The court said no. It didn't meet the standard for preliminary injunction. I will note that the court made that decision without the administrative record. Why the court didn't have the administrative record, I don't know. Why the advocates agreed to go forward without the court having the administrative record, I don't know. But the fact that the court didn't have the administrative record probably was something that affected the decision. So
What is the administrative record?
it's what the board and the department used in developing the rule. That's the administrative record, what was used in its decision to adopt the rule and then go forward with the rule or with the objection. Now, the court obviously had a lot of information. And I thought it was a well written, Tomasi's a good. But it's not the end of the case. And it's just the first step. It hasn't gone to the merits. The advocates have indicated that they're going to have an interlocutory appeal, which is you appeal as the litigation is ongoing. So basically, they're going to appeal the judge's decision here that the preliminary injunction it didn't meet the standard. This is going to go on for a while, but to say that this decision is somehow instructive or binding, that is not the case. And frankly, it doesn't matter anyway. Because you are the supreme lawmaking body. You can amend law, even when that law is being litigated. Your decision, your legislation might not affect the decision in that case because there's a provision that says legislation does not affect ongoing litigation. But you would affect every other application of the law. So it really, honestly, if you amend 258 as amend these provisions as 258 proposes, the issue is really.
So I just wanted us, because some people brought the suit up and court ruling and stuff like that. I just wanted to make sure that as a group, we had heard from council about it.
So do we have an administrative record or it just doesn't exist or just wasn't used, wasn't available?
I don't know.
Can we see the administrative record? Like, is that available to us? Like,
The administrative record is supposed to be a public record, but I can't answer whether or not there is one or whether it's complete or where it is or
oh,
so.
who would we ask?
That's the department as the staff of the board.
Okay.
I will just say that. You know, how the agencies keep the administrative record varies. They used to not be really good about it because it's the normal review on the environmental board, so. But then they've gotten a lot better. But I'm not criticizing the department here, I just don't know why.
Okay. No, it doesn't seem unnecessarily critical, it's just, that would be great information, and if they have it, I'd love to understand more.
You're welcome.
Thank you, I'm just wanted to know, because it seems like we're wrapping up.
Yeah.
This part, but we didn't actually. I guess we did, there are some changes that are gonna be made to this draft based on this conversation. But just noting that we didn't, it seems like there's still some unresolved things.
Yep.
So,
I have doubt, it's. One of the more discussable things, the notion of defining scientists to be added, for instance. But a lot of the other ones seem like they're sort of editorial form changes. That's
so I think
Have
those,
you looked at appointment authority in other states? Where it's not. A specific New Hampshire appointment. New Hampshire's pretty specific.
like, what, this person shall appoint someone from this county, that kind of thing.
Yeah, but here, for example, this is Washington State. In making these appointments, the governors shall seek to maintain a balance reflecting all aspects of fish and wildlife. Including representation recommended by organized groups representing sports fishers, commercial fishers, hunters, private landowners and environmentalists. And you see language like that in a lot of states. Where it's like you are supposed to represent all these people and then there's specified. Associations or groups that the appointments are supposed to represent.
That's very interesting.
So,
And then it doesn't, so it's a balance of these kinds of
right,
people, the representative groups.
I gotta go.
Okay, thank you. Thank you.
So busy.
We won't be voting today, just in case anyone, for us as a committee, for anyone following, we've got. We have a question to discuss on. Defining. Memberships by qualifications. And then Mr. Irving pointed out a number of. Legal technical changes to make so that things are properly structured. So I'm gonna ask you to make everything that we know we need to make, and leave the finance question open. If we can also, if we did have, the natural resource conservation districts coming in, I would be try to sort that out right now, unfortunately. 5 weeks ago, they asked if they could be in this morning, and it turns out that today's that day. But I think I would like to just take 7-minute break till they come in, 11:30. And then we'll return. So for people who are following this bill, I think we'll see another draft. We already have a very full day tomorrow on the battery EPR bill. I don't know if we'll loop back into it tomorrow or Thursday. It also depends when we can get our lawyer back in the room, because they get very fully scheduled. So we'll work on that.